Good evening. I'd like to welcome everybody to today's webinar. My name is Joe Esquivel, and on behalf of Mortgage Compliance Investigators, we're going to be presenting a lot of information that will really help a lot of the parties that are out there today in this fight. So with that, we're going to get started. First of all, I am not an attorney. Legal educational information is not the same as legal advice. The application of law varies with an individual's specific circumstances. We recommend that you consult a lawyer if you want professional assurance that this educational information and your interpretation of it is appropriate to your particular situation. Joe Esquivel does not offer legal advice and is not licensed to do so. Anything that I say today is for educational purposes only and my opinion. Here's today's agenda. This is what we are going to be going over. One, basic information as to what is an RMBS, and then we're going to be going over RMBS word definitions. Now, many of these definitions are similar to GSE word definitions. Okay, after that, we will be going over RMBS infographic without MERS, RMB infographics with MERS. After that, we will then get into negotiation, and we will be going over a number of different statutes, UCC 7501, UCC 3205, UCC 3203. What is an RMBS infographic? Well, a couple of months ago, I was asked by a number of different clients for a way to explain the chain of title analysis. So after sitting down for a couple of weeks and coming up with what I had put together, it is a graphical visual representation of information and data for residential mortgage-backed securities. It was designed to present complex information quickly and clearly. So what I've done is taken basically about 30 pages of legalese analysis for loan documents, and I put them into a one-page visual representation. So a lawyer, a judge, anyone can look at it and quickly ascertain what is going on. Okay, so I am the creator of the infographics, and again, they were intended to complement the chain of title analysis that Mortgage Compliance Investigators put out. So, what is a chain of title analysis? One, it's a comprehensive state-specific chain of title analysis. It addresses securitization and foreclosure issues surrounding the power of sale claims against real property using statutory requirements of law for each specific state. Meaning that if you are in New Mexico, I use New Mexico statutes. If you're in New York, we use New York statutes. Because we have judicial and non-judicial, we have different requirements of law. If you're in Louisiana, we use Neoplonic. So the chain of title analysis states what was to take place, what did take place, and what did not take place. And we do this, again, by using documentation provided to us and also by what's recorded into public record. Because you have what's called a chain of endorsements for the tangible promissory note, and you have chain of title, which is public record, giving constructive notice to the world. And these two need to match. Many, many times they do not match. All right, so this is why the chain of title analysis differs from what is perceived to be out there, a securitization audit. It is not an audit. It is an analysis, a comprehensive analysis. And when you look at it, you're able to understand what was to take place, what did take place, and what did not take place. So now let's get into some of the definitions. Okay, so these definitions. One, the definitions offered here are not substitutes for legal definitions provided by appropriate legal counsel. These definitions are provided to offer a general understanding of terms. Again, everybody learns different and they understand different. So these are definitions which I believe will help you understand what we're talking about. One, a mortgage loan. A mortgage loan is secured by real property through the use of a tangible promissory note, which evidences the debt and the encumbrance of property rights through the granting of a mortgage or deed of trust, which secures the loan. However, the word mortgage alone in everyday usage is most often used to mean mortgage loan. So when they say, I have a mortgage, they're talking generally about a mortgage loan. Now, if you were in the state of Florida, you would have a security deed. So, again, generalization. Now, what is a tangible promissory note? Many times people talk about what they believe they talk about in generalities. I have a note. Well, we have to be very precise. What do you have? You have a tangible promissory note. That means a promissory note, tangible, is a piece of paper that can be touched, that contains the promise to pay, but the real significance is not the physical paper, but the legal rights which the paper confers, and hence the promissory note is defined by the legal debt. The note is a tangible, negotiable instrument that evidences that evidences the intangible obligation, which is the right for future payments. And again, these definitions are used with GSEs and RMBSs. So, security instrument. The mortgage or deed of trust is seen as a real property lien if filed of record, and it is a separate contract listing an alternative means for collecting payment due under the intangible obligation evidenced by the tangible promissory note. Again, the magic word here is seen as a real property lien if filed of record. If it's not filed of record giving constructive notice to the world, then we do not have a real property lien. The entire instrument. Many times you hear people talking about the entire instrument and they don't fully understand it. So, the entire instrument is comprised of both documents, the tangible promissory note and a tangible security instrument, which would be either a mortgage or a deed of trust, along with the intangible obligation. For there to be a right to enforce any part of the entire instrument, all three parts, the tangible and the intangible, must be named to the same party. In the case of the tangible security instrument, named in public record, and in the case of the tangible promissory note on the document itself, and in the case of the intangible obligation in the transferable record. So, if Party A is coming forth to enforce an action, unless the note and the sole interest of that note is with Party A, along with the sole interest of the security instrument and the sole interest of the intangible obligation, one would have not obtained the rights to the entire instrument. Tangible obligor. This is a party whom signs the tangible promissory note. Tangible obligee. This is the party whom is named on the tangible promissory note as either lender or is properly named as payee on a payee line, physically affixed. Again, physically affixed to the tangible promissory note. Intangible obligor, this is the party that creates the intangible obligation using the intangible payment stream of the tangible promissory note. So, the intangible payment stream, we're talking about the right to collect future payments. Intangible obligee. Now, this is the party that purchases the intangible obligation from the intangible obligor. Now, they're seldom filed of record as to being the secured party to the tangible obligor security instrument. And the reason is many times the only thing that was purchased was the intangible payment obligation. And it was an unsecured obligation. It was not recorded into public. Had it been recorded into public, along with the proper sale, transfer, and delivery of the negotiable instrument, then they might have had a chance at securing this intangible obligation they had bought. The account debtor, originator. So under UCC Article 9, Secure Transactions, if you look in the general provisions under 9102, definitions and index of definitions, all right, when we go through the definitions, it talks about an account, except as used in account for. It means a right to payment of a monetary obligation, whether or not earned by performance, or for property that has been or is to be sold, leased, licensed, assigned, or otherwise disposed of, or for services rendered or to be rendered, or for a policy of insurance issued or to be issued, or for secondary obligation incurred or to be incurred, or for energy provided or to be provided, for the use of hire of a vessel under a charter or other contract, arising out of the use of a credit or charge card, or information contained on or for use with the card. Again, these are the rest of the definitions. I'm not going to go through them. You can read them later. However, within there, we have the definition of account debtor. Within the account debtor, the account debtor means a person obligated on an account, chattel paper, or general intangible. Again, a person obligated on an account, chattel paper, or general intangible. The term does not include persons obligated to pay a negotiable instrument, even if the instrument constitutes part of chattel paper. So, if I were Countrywide Home Loans and I created an intangible obligation, I would be the account debtor. I would be the person obligated on that account. I created, I'm obligated for it. What is MERS? MERS is Mortgage Electronic Registration Systems Incorporated. MERS is a wholly owned subsidiary of MERS Corp. Incorporated, and they serve as mortgagee in a nominee capacity for the lenders and subsequent assignees. MERS is an electronic database that is used to track the intangible obligation as well as the servicing rights. MERS does not operate in the tangible world. MERS operates only in the intangible. If you look up with the SEC and the registry and the filings for Mortgage Electronic Registration Systems Incorporated, it says that they are listed as an electronic registry. That is a type of business, an electronic registry. So that means that they operate with copies. They don't operate with tangibles. They can only operate in the intangible world. MERS Corp. Incorporated is a privately held shareholder corporation that operates the electronic database that is used for tracking the interest in mortgage loans as well as the servicing rights of the loans. Again, they operate in the intangible world, not the tangible world. And what they track is the beneficial interest, the rights to future payments, the servicing rights of the servicers, who is serving the account. This is what they track. Okay, so with that being said, we have a basic understanding of the word. So let's get started with the first infographic. This is an RMBS, residential mortgage-backed security, all right, with MERS. So we're going to go through and talk about what actually happens. We're going to use John Doe as a borrower. Okay, so we're going to start now. So we have John Doe over here on the left-hand side, and he goes to title. And he closes on March 14, 2005. Okay, now, when he is at closing, John Doe has anywhere between 60 and 80 documents that they sign. Now, among those documents, there is a tangible promissory note, and there is a mortgage, which is the security instrument. These are tangible documents. Okay, now, within this John Doe note, there is what's called a payment obligation. I promise to pay Countrywide Home Loans for the next 360 months, X number of dollars. That is the right to collect future payments. That is your promise. That is what is valuable. That is what is sold. Your mortgage is a separate contract. Now, after signing at title, okay, the John Doe mortgage is sent to the county recorder's office. Okay, when it is at the county recorder's office, it is filed, indexed, and recorded. Once that is done, constructive notice to the world has been given. And when constructive notice to the world has been given, we now have a perfection of lien. Right? We now have the security instrument to be attached to the debt, the legal debt, the promise to pay. Okay, so what happens is from the county recorder's office, they send it back to Countrywide. Within 24 to 48 hours after Countrywide getting the documents, all right, the paper note is scanned into the system and it's stamped with a payee unnamed. And then it's often vaulted or destroyed. Okay? At the same time, the Doe mortgage is also sent to the vault. Now, what happens next is that this is called the payment obligation. This payment intangible obligation is stripped and sold to the sponsor or the seller. The sponsor seller is one that sponsors the transactions. Now, when they've stripped out that payment intangible and they've sold it, because they can do that legally under UCC Article 9, all right, once they have sold that payment intangible obligation, all right, the note is no longer eligible for negotiation. Now, down here I put in pursuant to statute. Now, under UCC 3203 subsection D. Right? That is the Uniform Commercial Code under transfer of instrument and rights acquired by transfer. Now, all 50 states have codified some version of this. If you're in New York, you use in UCC 1961. It just depends on the state. So for this instance, let's just say we're going to talk about just Uniform Commercial Code 3203D, which states if a transfer purports to transfer less than the entire instrument, negotiation of the instrument does not occur. The transferee obtains no rights under this article and has only the rights of a partial assignee. So what they've done is they've stripped out this intangible payment obligation and they've sold it to the sponsor seller. Now, at the same time that they have done that, they have notified MERS what they have done. That's what this little dotted line is. All right, the sponsor seller then takes this intangible payment obligation and he sells it to the depositor. At the same time, the depositor lets MERS know, oh, I got it electronically. Now, the depositor then takes this intangible payment obligation and he sells it to the trustee for the trust. Again, everything is being done electronically. Many times at closing, there's only a week or 2 weeks between closing at signing of the homeowner's documents and the closing of the trust. And there would be no way to physically perfect each and every transaction. This is why they're using MERS, Mortgage Electronic Registrations, because they're using copies. Now, the only thing with using copies is that pursuant to 15 U.S.C. 7003, which says that Article 3 and Article 9 are excluded from e-sign and UETA. E-sign is the electronic assignment of signatures, and UETA is the Uniform Electronic Transmission Act. So we do not have any laws regarding the transfer of copies. We have laws regarding the transfer of a tangible instrument. So even though this purple line shows that all of this information has gone to MERS, it stays there. This is a private database. So even though there's thousands and thousands of members, it is not giving constructive notice to the world what's happened. What has happened so far is that Clark County Recorder's Office has a recording of the dual mortgage, and they're assuming that those are the rightful owners of the obligation, which was to be with the DOE note. Now, what happens to the note? We don't always know. Sometimes they say that it's been negotiated, but I have yet to see a complete endorsement and negotiation from front to back of the tangible promissory note that matches a complete chain of title of assignments, whether it be mortgage or deed of trust, from A to B, B to C, C to D, that would match the note showing from A to B, B to C, C to D. Everything is supposed to happen in tandem. When we have a sale of the tangible promissory note, at the same time, we would have a release of the beneficial interest in the security instrument and the reassignment. So if party A were to sell the note, the originator, to party B, at the same time he sold this tangible promissory note, it would have included this payment obligation, and they would have released the interest that they had in the mortgage and then assigned it, and they would have had an assignment go to the county recorders listing the sponsor seller as the new party to the Doe mortgage, thus perfecting the payment obligation to be with the Doe note. That doesn't happen. What happens is, usually upon default, 10 years, 20 years later, whatever the year is, they purport to do an assignment with a document that purports to be an assignment. But the reality is that many, many times these documents are ineligible to be recorded as assignments. Many times the documentation states that along with the assignment of a beneficial interest of mortgage or a beneficial interest of a deed of trust, that they are doing the assignment together with the note and principal and interest. However, the assignment does not memorialize any negotiation or sale. Now, yes, MERS could have assigned beneficial interest. However, that beneficial interest did not contain the rights to enforce the conditions over for collection, because when the intangible payment obligation was stripped out and sold, it left the note no debt for the mortgage to attach itself to. And as we all know in Carpenter versus Logan, which states the mortgage cannot survive a moment without the debt. So with the debt being sold forward, the value of the mortgage has been reduced. It cannot attach itself to. So again, when we have the originator, all right, who had sold the intangible payment obligation to the sponsor, who had then sold that intangible payment obligation to the depositor, who had then sold that payment intangible obligation to the trustee. And that trustee was holding it for the benefits of the RMBS trust. Now, if you notice, this trust has a closing date. The closing date here is June 30th, 2005. So if this were to have happened correctly, then we should have seen the sponsor and seller being recorded at the county recorder's office, the depositor being recorded at the county recorder's office, the trustee being recorded at the county recorder's office, all in conjunction with the proper negotiation and sale of the note, the payment intangible, and the assignment of the mortgage. So again, many years later, upon default, MERS purports to do an assignment. Again, they purport to put out a piece of paper. But if that paper does not contain the rights to transfer something that it never owned, then they've transferred nothing. But let's take a look at another infographic without MERS. Now in this one, we're going to show exactly, this is a little easier to show, what was to take place and what did take place. So we're going to start on the left. Now on the left-hand side, this is what was required by statutes and trust documents. Okay, so we've got the borrower, we have the originator, we have the sponsor and seller, and then we have the depositor, and then we have the trustee, and then down here we have the trust. So let's follow the transaction. Okay, so we're starting at the top. John and Jane Doe, they're at title, they sign their documents, they have the Doe note, the Doe mortgage. All right, so after signing, the Doe mortgage goes to the Clark County Recorder's Office. Okay, once it's been recorded, indexed, and filed of record, it's then sent back to the originator. Now we've got a properly perfected lien, attaching the intangible and the tangible. Now, Countrywide at that time decides, I need to sell this. So he sells the John Doe note containing the payment and tangible obligation, and it's transferred by endorsement and proper negotiation and delivery, and it's transferred to the sponsor seller. Okay. At the same time, the John Doe mortgage has been recorded, indexed, and filed at the county recorder's office. It then is sent to the sponsor seller. They now have a perfected lien. The mortgage has attached itself to the rights of payment. All right, the sponsor seller decides he wants to sell it, so it's transferred by endorsement, delivery, and proper negotiation to the depositor. At the same time, there is an assignment done of the John Doe mortgage, sent to the county recorder's office, recorded, filed, and indexed, and it's sent back. Again, we have now perfected the mortgage with the transferable record, with the tangible promissory note. All right, the depositor decides that he is going to sell what he owns and transfer. So he does a sale of the John Doe note with the intangible payment obligation attached to the trustee. The trustee for the RMBS Trust, in this case it's HSBC Trust 2005-6. At the same time that depositor makes the sale, he then files an assignment of record at the county recorder's office. It's filed, indexed, and recorded. It's then sent back. Now, the time frame for doing all of this would have normally taken a couple of months. And when we're talking billions and billions of dollars, this is where greed gets in the way. If you go back 30 years, when I bought my first condo, I remember people having parties, doing a note burning party and a deed of trust burning party. Because upon payment in full, they were given the instruments back and then they burned them. The chains were broken. They were no longer held down. Now, the difference is, by doing this electronically, they can accomplish this in days. By doing this physically, you're looking at over a month to go back and forth and back and forth, back and forth, a couple of months. So this is what is to happen. This is what it says is to happen in the pool and servicing agreements. It says that these are to be arm's length transactions. All right? Arm's length transactions, meaning from party to party B, then party B to party C, party C to party D. In addition, these transactions are to be in writing. Many states have what's called statute of frauds, and this was done to keep the honest people honest. Now, let's take a look at what actually happens. All right, so if we look over here on the right, we've got John Doe, and we have John Doe's note, John Doe's mortgage. Okay, so he signed at closing, and after closing, the Doe mortgage was sent to the county recorder's office. It was sent back to the originator. All right. Upon it coming back, we have a perfection. It's filed into public. It says Countrywide has perfected the lien that now encumbers this property. Now, upon Countrywide getting the loan back, the paper note and mortgage are scanned into the system. The note is stamped with a payee unnamed, and then is often vaulted or destroyed. Okay, the dough mortgage is sent with the note to a warehouse or destroyed. Okay, when it is scanned in the system, depending on the entity, some of them destroyed them immediately, some of them put them into vaults and lost them. It just depends on the entity and what they were doing with it. However, let's continue. Upon scanning into the system, all right, stamping with a payee yet unnamed, okay, the intangible payment obligation, which is the promise to pay, is stripped and transferred electronically. And again, to give you an example of this, imagine that you own a strip shopping center and you have 10 stores and you need to raise a little extra cash because you've fallen behind because of this recession we're in. So you come up with the idea, I can sell my leases. I've got tenants in all 10 of these stores. I still own the building, but I'm going to sell the leases, the right to collect future payments. And under Article 9, you can do that legally all day long. So that is similar to what is being done to the promissory tangible note. The intangible payment obligation is stripped and sold. Now, the consequence to selling this payment intangible obligation is that the tangible promissory note is no longer eligible for negotiation pursuant to UCC 3203D. So anything less, if the transfer purports to transfer anything less than the entire instrument, then the negotiation of the instrument does not occur. So by only selling a portion, this was less than the entire instrument, which was comprised of the tangibles, the note, and the mortgage, and intangible, the right to collect on future payments. So now, when this intangible payment obligation is stripped out, and it's sold. It's sold to the sponsor seller. So the sponsor seller sponsors the transaction, and they buy the intangible payment obligation. The note is possibly transferred and negotiated. There's no indication on record what has happened to it. It is with an unnamed party. So right now, the mortgage, again, it's either been sent to a warehouse, it's been destroyed, we don't know. This is where discovery comes in. So, however, with the stripping of this payment intangible obligation, the security instrument is no longer secured to the tangible note. So there are no conditions of enforcement that can be attached because this is now worthless personal property. The value has been stripped and sold. And then from the sponsor and seller, it has been sold again. And then from the depositor, it has been sold again. So with the mortgage being unable to attach itself to the debt, there are no ways to transfer to enforce the power of sale clause that is in the mortgage or in the deed of trust. So now many times, again, it usually happens only upon default of the intangible payment obligation. All right, an assignment is many times pops up. That assignment is filed at the county recorder's office, and many times they purport to do an assignment to this 2005 trust some 5, 6, 7, 8 years later. Now, one of the things for this trust is that it has a closing date. Now, this closing date is the last date in which assets can be put into the trust. Now, many of these trusts do have a 720-day extension that they allow an asset to be put in or taken out, and they call it, it's under what's called warranties and representations under substitution of loans. However, even given that time frame of 2 years, if this trust closed in June 1st of 2005, and we're looking at today as 2013, and they did an assignment 2 months ago, the doors have been slammed. They're trying to reattach something. They're trying to reattach conditions to enforce a power of sale clause that is contained in the security instrument, but it's not attached to the note. There has been no proper negotiation of the tangible promissory note. So pursuant to UCC 3203D, negotiation cannot take place, did not take place. And many times the documents that they purport to show into exhibit for court are incomplete documents. We'll go over a few examples in a few minutes. So this is what usually happens. And again, depending on the situation, I've probably created about 15 or 20 different scenarios for the different charts. In some instances, there is no sponsor or seller. The originator wears many hats. The originator could be the originator, the sponsor, the seller. So it would go from the originator to the depositor. It depends on the guidelines that were set up within the trust. But now we get into, many times we have banks purport to come up with documents. And the documents that they come up with are their own verbiage of documents, meaning they claim that the document they have is a bearer paper. So I've looked up and I provided a few examples of true bearer paper. Now, bearer paper says, will pay to bearer. Again, the word is spelled out, will pay to bearer. Okay, I understand that. At the county of the county treasurer. Let's look at the next example. The all-new bearer instrument, payable to bearer upon demand. Again, we're identifying who is getting what. Payable to bearer. This is a bearer instrument. All right, let's take a look at the next example we have. Anybody recognize this? Yes, this is a Federal Reserve note. This says payable to bearer on demand as authorized by law. Again, payable to bearer, B-E-A-R-E-R. It states exactly what the instructions intend. Let's look at the next document. Okay, we have another one. This is a Federal Reserve note for $10,000. As everybody can see, it says, will pay to the bearer on demand. These are examples of bearer instruments. At all times, you have seen the word bearer. B-E-A-R-E-R. All right, that then means that one whom is in possession. Now, the banks claim that they have instruments that are bearer instruments. However, their instruments are not bearer instruments. Their instruments, I missed the page, are order instruments. Order instruments say pay to the order. All right, it's order paper. If everyone out there were to imagine grabbing your checkbook, and your checkbook, you take out a check and let's fill it in. It says pay to the order of. Okay, so when it says pay to the order of, we're not going to fill it in. But what we're going to do is we're just going to fill in a date and a dollar amount, and we're going to sign it, and we're going to go to the bank because we're in a hurry. Now, when we get to the bank and you say, Mr. Banker, I'd like to cash it. And the bank says, well, there's no payee name. Put your name on there. No, I'm in a hurry. Can we just cash? I'd like to negotiate this. No. It says pay to the order of. We need to have an identified party. Without an identified party, negotiation cannot take place. So when it says pay to the order, right, you're giving it a set of specific instructions. Without that set of instructions filled in, okay, we don't know. All right? So, again, order paper says pay to the order. Now, on all of the documents that I have handled over the last couple of years, I have never seen a document come across my desk saying pay to bearer. Everyone that I have seen says pay to the order of. Now, we've all been indoctrinated over decades as to word crafting. You're going to take a test, and the person giving the test says, I've attached a form with a lot of blanks, fill them in. Now, the banks come forth years later and they say, we have a document that's endorsed in blank. It's not filled in, it's a blank endorsement. Well, let's talk about this a second. If we look under UCC 3204 for endorsement, endorsement means a signature other than that of a signer as maker, drawer, or acceptor, that alone or accompanied by other words is made on an instrument for the purpose of negotiating the instrument, restricting payment of the instrument, or incurring the endorser's liability on the instrument. But regardless of the intent of the signer, a signature and the accompanying words is an endorsement. Unless the accompanying words, the terms of the instrument, and the place of the signature, or other circumstances indicate that the signature was made for a purpose other than endorsement. So now, a blank endorsement, all right? Well, it says endorsement means signature. So a blank endorsement would be your name, John Doe. That's it. That is a blank endorsement. A blank endorsement, again, consists of a signature. If we have a payee line that is not filled in, it is an incomplete set of instructions. And until that set of instructions is completed, negotiation cannot take place. Now, we have what's called a special endorsement. Now, a special endorsement falls under UCC 3205. All right, and it says if an endorsement is made by the holder of an instrument, whether payable to an identified person, paid to the order of, all right, an identified person, or payable to bearer, B-E-A-R-E-R, okay, and the endorsement identifies a party to whom it makes the instrument payable, then it is a special endorsement. When specially endorsed, the instrument becomes payable to the identified person and may be negotiated only by the endorsement of that person. So now it's saying only when endorsed. So in other words, unless we have a signature, endorsement does not take place. And it also says identified person. How many of you have gone to the bank to cash a check and you write your name on the back of the check and you've seen the teller 100 times over the last 10 years and they say, excuse me, Joe, may I see your identification? Oh, you know me, Sam. Joe, I need to see your license. Oh, I'm in a hurry. I forgot my wallet. Well, you know what? I can't cash your check. The reason is the whole purpose of setting up the Uniform Commercial Code was to allow commercial transactions to take place easily and transferably as readily as cash. So when they say that it must be made to an identified person or payable to bearer, again, it would have said paid to the order of bearer, B-E-A-R-E-R. It doesn't. So in that case, you must identify yourself. Now, if an endorsement is made by the holder of the instrument and is not a special endorsement, then it is a blank endorsement. When endorsed in blank, an instrument becomes payable to bearer and may be negotiated by transfer of possession alone until specially endorsed. Now, a good way to look at this, if you were to replace the word endorsement with signature, all right? Because we already have gone through what is an endorsement. An endorsement is a signature. So if the signature was made by the holder of an instrument and is not a special endorsement, it is a blank signature. Again, a blank endorsement. I'm just putting words in so you can visually look at it. Blank endorsement, John Doe. Special endorsement, paid to the order of. Restrictive endorsements were given restrictions on what is to happen. All right. In this case, it says for deposit only. We are restricting what can be done with the funds. So if we have an endorsement that says, again, for deposit only, we're restricting it. If this said without recourse, we are restricting it. Every one of these, again, blank endorsement, Sally Brown. Special endorsement, paid to the order of. Restrictive endorsement, for deposit only, without recourse. So when I look at a document and I see, for example, this, I see one endorsement that is complete, and I see a second stamp with incomplete set of instructions. So let's pretend that these stamps were on the notes that were pertaining to the infographic that we looked at. And this is John Doe's note. So let's look at it. So this is at the bottom of the John Doe note. So the John Doe note has been endorsed by Countrywide Bank FSB. Okay. The endorsement states paid to the order of Countrywide Home Loans Inc. without recourse. So this constitutes a negotiation under UCC Article 3 concerning negotiable instruments. So with a payee named, clearly Countrywide Bank FSB has released and transferred all rights from the Doe note okay, to Countrywide Home Loans, Inc. Okay? Now, the dough note has also been signed by Countrywide Home Loans, Inc. Okay? Now, the instruction preceding the signature states, pay to the order of, and it's incomplete, without recourse. Now, with the instructions of the signer incomplete, this signature does not constitute a negotiation under UCC Article 3 and is not an endorsement in blank, as the banks would lead you to believe. With no payee yet named, no transfer had occurred through which rights could be acquired. Now, Countrywide Home Loans, Inc., along with signing away all rights to the dough note, wrote instructions that it made its intention of the negotiation of the note clear. The intention was that Countrywide Home Loans, Inc. negotiation of the John Doe note will only be complete when the payee is named. So, the John Doe note with an as of yet unnamed payee is not and cannot be treated as bearer paper, as no person will acquire any right to the John Doe note until the payee is named. All right. If we look under Uniform Commercial Code 3-110, which is under identification of persons to whom instrument payable, under Section A, it states, the person to whom an instrument is initially payable is determined by the intent of the person, whether or not authorized signing as or in the name of or on behalf of the issuer of the instrument. The instrument is payable to the person intended by the signer, even if that person is identified in the person by a name or identification that is not of the intended person. So, under UCC Commercial Code 3203A, which is the transfer of the dough note through which rights could be acquired by a transferee, is defined as a delivery from one person to the other. Okay? But now when we go down to, again, we go to 3203A, where it says transfer of instrument rights acquired by transfer. An instrument is transferred when it is delivered by a person other than its issuer for the purpose of giving to the person receiving delivery the right to enforce the instrument. This hasn't been filled in. We know what the intent of this incomplete set of instructions is, all right, that Countrywide Home Loans is going to release its rights. However, without a named payee or identified party, negotiation cannot take place and does not take place. However, the word crafting that we've been going through with the banks, again, is just that of itself. It is word crafting. They claim we own it, we bear it. No, you don't. You may be the holder of personal property, but that's about it. All right. If we were to go to the comment 7 of the official comments to Section 3, UCC 3201, subsection 3, it states 3201, subsection 3 reiterates that until the endorsement is made, the purchaser does not become a holder, and if he receives earlier notice of defense against or claim to the instrument, he does not qualify as a holder in due course under Section 3-102, subsection 1, subsection C. Again, the more educated we are in understanding the requirements of law, the better we are going to be able to proceed in this fight. By understanding that these documents belong to order paper and not bearer paper is a big step in and of itself. So with that, I hope that everyone has gained a little bit of knowledge today. And on behalf of myself, Joe Esquivel, and all of us at Mortgage Compliant Investigator. I'd like to thank everyone for joining the webinar today. If anybody would like more information on receiving a chain of title analysis, you may call us at 888-491-3741, or you can email us at info@mortgagecomplianceinvestigators.com. So with that, I'm going to close, and I hope that everybody has enjoyed it. And I will be having a link tomorrow sometime that I will be posting this on our website, and we'll be having this up on YouTube as well. Secondly, in 2 weeks, I will be doing another free webinar on MERS, and then 3 days after that, I will be doing a live 8-hour seminar in Las Vegas. So I'd like everybody to join us, and I will talk to you soon. And have a nice evening. Thank you.